Imagine getting a letter in the mail that says you owe money to a group you never joined. You laugh at first, until the next letter comes from a lawyer, then a court summons, then a lawsuit. That's when I realized this wasn't a mistake. This was an HOA trying to bully someone who wasn't even in their neighborhood. They told the court I was delinquent. They told the judge I refused to pay my dues. There was just one problem with their story. I was never part of the HOA at all. No contract, no vote, no authority. What started as a few threatening notices turned into a full-blown courtroom drama, and by the end of it, the judge didn't just dismiss their claims, he ordered the HOA itself dissolved. This isn't just my story. It's a warning about what happens when power goes unchecked and intimidation meets the truth. An HOA tried to enforce power it never legally had, and it did so with absolute confidence, the kind of confidence that only comes from years of never being challenged. It began quietly, the way these things always do, with a letter that looked official enough to make someone pause, but casual enough to dismiss. It claimed unpaid dues, late fees, penalties stacked neatly in bold numbers, and a reminder of community obligations. The strange part was not the amount or the language, but the assumption behind it, the unquestioned belief that I belonged to them. I didn't. I never signed anything. I never voted. I never attended a meeting. My property was not governed by their bylaws, their covenants, or their authority. But the HOA didn't ask whether they had the right. They acted as if the right already existed. That assumption hardened quickly into pressure. The letters became more frequent, the tone sharper. What started as reminders turned into warnings, and warnings turned into threats. They referenced liens, collections, damage to credit, even foreclosure, all tools designed to scare people into compliance before questions could be asked. HOAs rely on fear more than facts because fear works faster. Most people panic. Most people pay. Most people never stop to ask the most dangerous question of all. Who gave you this power? The HOA didn't expect that question from me, and they certainly didn't expect me to keep asking it. Instead of answers, I got escalation. Lawyers' names appeared on letterheads. Deadlines were imposed. Penalties multiplied. Every communication assumed guilt. Every sentence was written as if the matter had already been settled, as if I had already agreed to be governed by them and simply failed to comply. That's how illegitimate authority operates. It speaks in conclusions, not arguments. It doesn't prove. It declares. The HOA wasn't trying to establish jurisdiction. It was pretending it didn't need to. When I pushed back, politely at first, asking for proof of membership, proof of jurisdiction, proof of any binding agreement, the response was silence followed by aggression. Silence is strategic. It's meant to make you doubt yourself. Then comes aggression, meant to overwhelm you. The HOA skipped over the inconvenient step of proving authority and jumped straight to enforcement, filing a lawsuit that read like a script they had used dozens of times before. They listed me as a homeowner in their association. They claimed I was bound by their rules. They accused me of refusing to pay dues I never owed. They treated fiction as fact because, in their experience, fiction had always been enough. What they underestimated was the paper trail. Authority leaves fingerprints. Real authority is documented, traceable, signed, recorded. It exists in deeds, plats, covenants, and contracts. When you start asking for those documents, the story either solidifies or collapses. The HOA's story collapsed. There was no covenant tying my property to them, no recorded document placing my land within their jurisdiction, no agreement, implied or otherwise, that gave them control. They were enforcing power out of habit, not law. In court, that habit became visible. The HOA's representatives spoke with confidence but not clarity. They referenced the community, established practices, and standard enforcement, phrases that sound authoritative until you ask them to define the boundary where that authority begins. When asked to show how my property was included, they deflected. When pressed for documents, they produced irrelevant ones. When challenged on jurisdiction, they relied on assumptions. Courts don't run on assumptions. Courts run on evidence. What became clear was that the HOA had grown comfortable operating in a gray zone, expanding its reach inch by inch over time, assuming no one would push back hard enough to expose the overreach. They had sent bills to properties that weren't theirs to govern, and no one had objected loudly enough to matter. That silence had emboldened them. Power unchallenged always grows careless. It forgets the limits that created it. The judge didn't respond to their confidence. The judge responded to the absence beneath it. Each unanswered question weakened the HOA's position. Each missing document widened the gap between what they claimed and what they could prove. The lawsuit, intended to intimidate, turned into a spotlight. Under that light, the HOA's authority didn't just look questionable, it looked fabricated. This wasn't about unpaid dues anymore. It was about whether an organization could assert control without consent, enforce penalties without jurisdiction, and weaponize the legal system to compensate for the authority it never possessed. The court recognized that allowing this behavior to stand would validate a dangerous precedent, one where confidence replaces consent and repetition replaces legality. As the case unfolded, it became apparent that the HOA's problems extended beyond my situation. Their governing documents were inconsistent, their boundaries were unclear, their enforcement practices relied more on assumption than verification. What was meant to be a simple collection case exposed structural flaws in the organization itself. An HOA derives its legitimacy entirely from its documents and compliance with the law. Without that foundation, it's just a group making demands. The judge didn't just question the HOA's claim over me. The judge questioned the HOA's existence in its current form. If it could not clearly define who it governed, if it could not demonstrate lawful authority, then its actions weren't just mistaken. They were invalid. The courtroom shifted from a dispute between an individual and an association to an examination of whether that association was operating lawfully at all. That moment is what organizations like HOAS fear most. Not resistance, but scrutiny. Resistance can be worn down. Scrutiny exposes. Under scrutiny, patterns emerge. Under scrutiny, shortcuts are revealed. Under scrutiny, authority must justify itself or disappear. The HOA had tried to enforce power it never legally had, and in doing so it invited the very examination that stripped it of credibility. The tactics that once worked, intimidation, volume, confidence, failed when confronted with documentation and law. The assumption that no one would fight back proved fatal to their position. Every threat they had issued became evidence of overreach. Every demand became proof of abuse. What made this situation especially revealing was how ordinary it was to them. They weren't acting out of malice so much as routine. This was how they operated. This was how they enforced. That normalcy is what made it dangerous. When unlawful behavior becomes routine, it stops being questioned internally. It becomes policy by default. It spreads quietly until someone refuses to comply. The courtroom didn't reward their routine. It dismantled it piece by piece. The judge's questions cut through the noise and focused on the core issue. Authority is not self-declared. It is granted, limited, and conditional. Without those conditions met, enforcement is nothing more than coercion dressed up as governance. As the case moved forward, the HOA's inability to establish its legal footing became impossible to ignore. The lawsuit that was supposed to extract money ended up extracting truth. The truth was that the HOA had been operating beyond its scope, relying on fear and assumption rather than law and consent. And once that truth was laid bare, the structure that supported their claimed power began to crumble under its own weight. Standing up to intimidation exposed the truth and ended the HOA itself. But that outcome was never supposed to happen. Intimidation is designed to stop stories before they reach daylight. It depends on imbalance of knowledge, of money, of confidence. From the HOA's perspective, the equation was simple. They had lawyers, letterhead, and a reputation for consequences. I had one property and one voice. The expectation was compliance, not resistance. They counted on the familiar pattern where pressure creates silence, and silence becomes admission. What they didn't anticipate was that intimidation only works when it goes unchallenged. The moment I refused to fold, the dynamic changed. Every threat forced them to commit to a claim. Every escalation required them to double down on an assumption that hadn't been proven. Intimidation thrives in vagueness, but resistance demands specifics. When I asked for clarity about jurisdiction, authority, documentation, the fog they relied on began to thin. Instead of scaring me into paying, they pushed themselves into a position where they had to explain. The legal system is often overwhelming by design, and organizations like HOAS exploit that. They assume individuals won't have the time, energy, or resources to push back. They use complexity as a weapon. Deadlines, procedures, filings, and formal language are meant to exhaust before truth ever enters the room. But intimidation loses power when it's met with persistence. Each step I took wasn't dramatic. It was methodical. Requests for records, motions for clarity, objections grounded in law rather than emotion. What felt small individually became cumulative pressure on an organization that was used to being obeyed, not questioned. As the case progressed, the HOA's tone shifted. The confidence in their filings began to sound rehearsed instead of grounded. Their arguments relied heavily on precedent without relevance, citing cases that assumed valid authority rather than proving it existed here. That distinction mattered. Standing up to intimidation isn't about shouting louder. It's about refusing to accept conclusions without evidence. The HOA kept presenting conclusions. The court kept asking for evidence. What intimidation hides is fragility. An organization that truly operates within the law doesn't need to threaten first. It can explain. It can demonstrate. It can withstand scrutiny. The HOA couldn't. Every time they were pressed, they revealed another gap. A missing record here, an outdated document there, inconsistencies between what they claimed publicly and what they could support legally. Each gap alone might have been dismissed as administrative error. Together, they formed a pattern of negligence and overreach. Standing up also shifted the emotional landscape of the courtroom. Fear was replaced with curiosity. Instead of focusing on alleged non-payment, the judge began focusing on governance. How was the HOA formed? Were its boundaries properly recorded? Were its enforcement actions consistent with state law? These questions weren't raised by the HOA. They were triggered by resistance. Intimidation had forced the issue into court, but standing up redirected the spotlight. As more information came out, it became clear that my case wasn't an anomaly. The HOA had sent similar notices to other properties on the edges of its claimed territory. Some had paid without question. Some had ignored the letters and hoped they'd go away. None had pushed the issue far enough to force a judicial review of the HOA's authority. That silence had protected the HOA more than any legal argument ever could. Breaking that silence didn't just help my case, it exposed a system operating on compliance rather than consent. The truth didn't arrive all at once. It emerged slowly. Through filings, testimony, and questions, the HOA struggled to answer. Standing up meant staying present through every step, resisting the urge to disengage when things became tedious or stressful. Intimidation counts on fatigue. It assumes people will give up halfway through the process. Persistence, in contrast, turns time into an ally. The longer the case went on, the more the HOA had to reveal, and the more their story unraveled. There was a moment when the HOA attempted to settle quietly. Not an admission, not an apology, just an offer to resolve the matter if I agreed to certain terms. That offer said more than any argument they made in court. It acknowledged risk. It acknowledged weakness. Intimidation doesn't seek settlement from a position of strength. It seeks it when the ground starts to shift. Refusing that offer wasn't about stubbornness. It was about understanding that the issue was bigger than a single dispute. Once the court began examining the HOA itself, the consequences expanded beyond my situation. Governance failures have ripple effects. If an HOA lacks clear authority, every action it has taken comes into question. Fines, liens, collections, rules enforcement, all of it depends on legitimacy. Standing up forced the court to consider whether this organization should be allowed to continue operating in a way that created legal risk for homeowners and property owners alike. The HOA's representatives struggled under that weight. They were no longer defending a bill, they were defending an institution. Their answers became cautious, then evasive. When asked direct questions, they responded with generalities. When asked for records, they requested time. The intimidation that once flowed outward now turned inward. Scrutiny has that effect. It reverses pressure. It exposes who is prepared and who has been coasting. The judge's patience narrowed as the gaps widened. Courts are designed to resolve disputes, not enable ongoing uncertainty. The inability of the HOA to clearly define its authority wasn't just inconvenient, it was unacceptable. An organization that governs property must do so with precision. Anything less creates harm. The truth, once exposed, couldn't be unexposed. It sat on the record, undeniable and documented. Standing up transformed the narrative. What began as an attempt to collect money became a case study in unchecked power. The HOA's intimidation tactics, once seen as routine enforcement, were recontextualized as coercive actions taken without proper authority. That shift mattered. It reframed their behavior from administrative to abusive. And once behavior is recognized as abusive, tolerance for it disappears quickly. The decision to dissolve the HOA wasn't dramatic, it was logical. An organization that cannot establish lawful authority cannot continue to exercise power over others. Dissolution wasn't punishment, it was correction. It was the legal system restoring boundaries that had been ignored. Standing up didn't destroy the HOA. It revealed that the HOA had already undermined itself. The aftermath was quiet. No grand announcements, no apologies. Just the absence of an entity that had once operated loudly and aggressively. That silence was the result of truth replacing intimidation. It demonstrated that even entrenched systems depend on compliance to survive. When compliance is replaced with challenge, those systems must either justify themselves or cease to exist. Standing up is often portrayed as heroic or dramatic, but in reality it's procedural. It's showing up. It's reading documents. It's asking uncomfortable questions and waiting for real answers. Intimidation thrives on speed and fear. Truth moves slower, but it's heavier. Once it lands, it changes what's possible. What ended the HOA wasn't anger or defiance. It was exposure. Intimidation collapsed under the weight of transparency. An organization built on unchallenged authority couldn't survive being examined, and the act of standing up ensured that examination happened in full view of the law.